Good afternoon and welcome to the Public Service Commission of South Carolina. We are here today for an interview with a prospective independent third-party consultant for the 2023 avoided cost cases. Let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Thomas, Commissioner Caston, and Vice Chair Belser. With us virtually, we have Commissioner Carolee Williams, Commissioner Irvin, and Commissioner Powers. Ms. Hill, General Counsel Hill, let me recognize you to read the docket.
Thank you and good afternoon, Vice Chair Belser and Commissioners. This is a special business meeting of the Commission. The only item on your agenda today is to conduct the public interview of London Economics International, LLC, related to the proposal in response to solicitations in dockets number 2023-15E, 2023-16E, and 2023-17E.
Thank you, General Counsel Hill. Appreciate it. And we have a representative from London Economics International. Is that correct?
That's correct.
Good morning, Mr. Goulding. How about state your name for us? Or good afternoon.
So my name is A.J. Goulding.
Thank you very much, Mr. Goulding. It's nice to see you today. I'm going to kick things off, Mr. Goulding, and just do a little bit of explanation here. In the last avoided cost cases, we did not retain the consultant until after the applications were filed by the utilities, and for the upcoming proceedings next year, we are trying to get the independent third-party consultant selected before the applications are filed so that the consultant can work through his pleadings, materials, discovery by parties, and other matters are filed. So there are some precautions that we will have to ask about with regard to potential conflicts that could come after the fact. But thank you for being here today. Do you want to make some opening presentation for us?
Sure. I'd like to just briefly present my qualifications and those of my firm. I'm grateful to have the opportunity to present to all of you this afternoon. I am the president of London Economics International. I also serve as an adjunct associate professor at Columbia University School of International and Public Affairs, where I teach electricity markets. London Economics International is a U.S. firm based in Boston. Been in business for about 25 years, if we count some predecessor firms. And I have been with the firm for almost that long. My background is in regulatory economics. I have a master's degree from Columbia in international business, an undergraduate degree from a small school in Indiana called Earlham College. That degree is in economics. And I've spent all of my professional career focused on energy and electricity matters. That I've been fortunate to have the opportunity to work both in the United States and outside. I have had the opportunity to testify in regulatory matters before yourselves, as well as in a number of Canadian provinces. I have served as an expert in commercial disputes related to electricity as well. The firm has three main practice areas: regulatory economics, which encompasses tariff and rate design, market design, and also market rules is one of those practice areas. The second is transactional. We assist in the valuation of various energy sector assets at all parts of the value chain, including using our own proprietary models. And the third is strategy and litigation support, which I say half facetiously. People feel that as economists, we ought to be able to add, subtract, multiply, and divide. And so we're asked to do some quantitative analysis. And we are known for having a deep understanding of the sector. So those two elements sometimes are useful in various kinds of disputes and regulatory matters. So hopefully that wasn't too long, but it gives you a sense of both my background and of the firm that supports me.
Thank you, Mr. Goulding. I'm gonna take the prerogative of the chair and go over some preliminary matters with you. The schedule for the 2023 proceedings has not been set. However, this commissioner anticipates that to have the avoided cost applications filed in the spring of 2023, March or April. I anticipate that hearings would be scheduled in the July, August, possibly, well, I anticipate a bifurcated proceeding where the utilities would present their evidence, interveners could present theirs, cross-examination in the July to August timeframe, allow the consultant time to complete their report based on their review of the application, whatever discovery and testimony presented at the hearing, and then bring the consultant in for presentation of their report and questioning by the parties if the parties choose. That would happen sometime probably in the September, maybe beginning of October timeframe. That would be pushing it. We have to have a decision by no later than mid-November. Are you aware of any conflicts or scheduling issues that would hamper your and your colleagues' ability to do the work, say, between March and October of 2023 to do the analysis needed to review these avoided cost dockets?
No, I'm not aware of anything that would conflict. We are fortunate that we always have plenty of things to do, but we're always, well, I always worry about using words like always, but we are able to manage around them. So I'm confident that we would be able to work within that time frame.
Okay. As you may recall, our commission has a fairly strict statute and rules regarding ex parte communications. And in addition, the commission and all of our employees are subject to the not only those ex parte communication statutes, but also subject to the Code of Judicial Conduct. And due to these restrictions, the commission cannot provide day-to-day directions to the independent third-party consultant. Would that create a hardship for you and your firm?
No, it's not a hardship. I think that the challenges are sometimes in making sure that you don't fall afoul of those if you're asking, kind of what would appear to be fairly innocuous questions, like, did we pull the right file or something along those lines. I think what we learned last time is that, we just need to be aware of what those procedures are, because everything has to flow through the appropriate process. And so the arrangements are a bit unique, but I don't see them as being a challenge.
The consultant hired for this project must be able to work independently without commission involvement in order to provide what the statute terms as independently derived conclusions as to the consultant's opinion on each utility's calculation of avoided cost. In getting to that point, the statute allows the third-party consultant to or seek information from the parties, issue discovery to the parties. Is that something that you and your colleagues are able to do as far as drafting some sort of discovery request to get information from the utilities and potentially other parties to the dockets?
Yes, that's not unusual for us. It's something that we have done in a number of regulatory proceedings. And I don't anticipate that we would face difficulty in doing it were we to be hired for this particular engagement.
The statute also allows that if responses are not forthcoming or perhaps are not complete, that the consultant can ask the commission for relief in the form of asking the commission to compel responses. Would that be a problem for you and your team?
No, it's something that we would try. It really is a last resort, and you have to make sure that that what you're asking for is really required in order to do the analysis. But if that were the case, then we would follow the appropriate procedure.
Under the statute that we're operating under, the utilities may require confidentiality agreements on some of the information sought. Is that something that you and your group are accustomed to dealing with, confidentiality agreements?
Yes.
Okay. The statute also requires that the third-party consultant's duty is to the commission in the standpoint that from an independent perspective, the consultant's response and are supposed to be independent and geared toward the commission and helping the commission in evaluating the avoided cost filings. Are you aware of that?
Yes.
Okay. There's some other requirements in the statute that are there, but how can you describe how your firm would design a report to meet the statutory requirements of independent third-party analysis of the avoided costs that are put forth by the utilities?
Sure. I think that we tend to approach these kinds of engagements using a similar framework adopted for the specific needs of the engagement. And so we would start off by summarizing the requirements under statute. We would then summarize the submissions of the utility. Next, we would develop a framework to go through on a point-by-point basis and compare what the utility has submitted to what's required by the statute. Following that, we would develop a series of observations. If necessary, we would perform some quantitative calculations. And then ultimately, we would summarize our conclusions about the extent to which the submission was consistent with what's required under the statute.
And just kind of as a general, this is probably my last really general question. To the extent that any report rendered may contain or need to contain confidential information, is there any problem or issue with submitting both a confidential version and a redacted version of the ultimate report?
No, there's no problem with that.
Okay. And I said that was my last one. I should never say that. And if selected, are you aware, and is somebody available from your firm to present in person, well, either in person or via electronic means, testimony to support the report and answer questions from the parties regarding the report, how it was derived, or it's basically cross-examination? Is that something that y'all are able to do?
Yes, I would anticipate that would be myself, and certainly subject to whatever the travel requirements were at the time. I would certainly hope to have a visit to South Carolina if we were selected for this engagement.
Okay. Thank you. I'm going to recognize other commissioners. Mr. Golding, I would note we have a couple of commissioners that are in training today, and I think they have to click off at 2 o'clock. So if we run beyond that, just be aware that we could have a couple of commissioners disappear from the screen, and just understand that they are undergoing some training classes today. They will have benefit of the transcript and the video if they have to leave before we finish. Just want you to be aware.
I won't assume that it's anything that I said that caused their departure. So.
Thank you, sir. Commissioners, any questions?
Madam Vice Chair,
Commissioner Thomas?
thank you. Good afternoon, Mr. Golding.
Good afternoon.
So I'm going to run through a few questions here with you. So have you ever been employed or retained as a consultant for Duke Energy Carolinas, Duke Energy Progress, or Dominion Energy, or any of their affiliates?
Yes, so I was looking at that question in preparation. I would say not in the past 15 years. Early in my career, at least 20 years ago, I was on a team that had an engagement with Dominion. But as I say, that's been probably almost 2 decades ago.
Okay, and given that passage of time and any other considerations, do you think that you can be independent with regards to the Dominion Energy Company filing?
Yes, I'm confident that I can be independent with regards to the filing.
All right, have you or your employees or associates or contractors or partners ever been retained to represent investor-owned utilities in South Carolina, other than the one that you recently completed with us?
No.
All right, do you or members of your immediate family or partners or associates own stock in the Duke Energy companies or Dominion Energy?
Not to the best of my knowledge. I don't know the details of all the portfolios of everyone in my family, but to the best of my knowledge, nobody owns a stock in either of those entities.
Do you have any reason to believe that you cannot serve as fair, impartial, or independent consultant for any of these dockets?
No.
And if you were hired as a consultant, are you willing to abstain from any unauthorized ex parte contact with the current or future parties in these dockets?
Yes.
So does your firm contribute to any political action committees?
No.
Is anyone in your organization in the past is there anyone who worked for your organization in the past who currently works for a public utility or solar company?
Just so that I'm clear, you're asking, is there anybody who formerly worked for our firm who now works for a utility or solar company? If that's the case, I believe the answer is yes, not a recent departure. But I think in the last 5 years, there's folks that have left to join other utilities or solar companies.
Okay, and do you think that interferes with your independence in any way?
No.
And so is there anyone associated with your organization who has any affiliation with a public utility or solar company?
Any current affiliation?
Yes, sir. Yes, sir.
Yeah, not that I'm aware of, no.
Okay. So, given that you did work with the South Carolina Public Service Commission previously on these dockets, do you believe that you can approach this with a complete fresh look and keep whatever was learned in the prior engagement separate from this, and just basically look at this with a complete fresh perspective?
Yes, the focus has to be what's on the record currently, not anything that would have been on the record in the past.
Okay, thank you. I'm gonna end my questioning at this time. I appreciate that.
Commissioners, anybody else?
Madam Chair,
Is that Commissioner
Sheldon Powers.
Commissioner Powers? Please go ahead.
Thank you very much. I really just have, I think, one question. You're getting, or if you're hired as, in this case, as opposed to the last case where you were hired after the hearing itself, will that change your approach, or how do you see going about this any differently as far as what you're required to do?
It's an interesting question because there are limits to what you can do really in advance of seeing all of the filings. Although I believe that the timeline in the previous engagement, there would have been a bit more time even to review the things that were actually filed. And I think that's really critical, is getting that additional time. I think knowing in advance, of course, it's beneficial to allow us to steer clear of conflicts. It also allows us to, plan our resourcing in a more, with more foresight. But I think that it's really a matter of having a little bit more time to view the filings. I think one of the challenges we faced in the previous proceeding was it was more difficult, given the procedural schedule, to issue discovery requests as timely as we would have liked. I don't believe that impacted the final product, but it's having more time will enable us to be as comprehensive as is reasonable.
Will you be able to listen to the testimony, observe the hearing itself, or what do you expect as far as that involvement?
Yeah, so I believe in the previous proceeding, as soon as we were engaged, we had folks from my team that were observing everything, and provided me with notes, observations, made sure that we focused on something as close to real time as possible. And I'm sure that were we to be engaged, we would follow a similar practice.
And I guess I'm just saying that as a lawyer, I get a lot out of watching people, their reactions, their body language, the whole thing. And that's something that just always has been a part of the way I look at things. Thank you very much. That's all I have, Madam Vice Chair.
Thank you, Commissioner Powers. Any other commissioners?
Vice Chair Belson.
Commissioner Caston.
Good afternoon, Mr. Golden. Good to see you again.
I'm pleased to have the opportunity to interact with you again.
I don't remember if Vice Chair Belser or Commissioner Thomas asked this question. So I'll ask it again just in case. Could you, or can you, will your firm be able to provide a final written proof of a conflicts check from your firm?
Yes.
Okay, good. Thank you. Relative to the schedule, and I know Vice Chair Belser went over an anticipated schedule, and I think you responded you did not anticipate any issues with at least what Judd talked about, and possibly, I guess, a final product in the September to October range. Is that true? Is that correct? Did I understand that correctly?
Yes, I believe that's the schedule that she went through.
And the task, I think, actually for the Duke companies and Dominion, the proposed work plan, that the tasks were, well, basically the same. Correct?
Yes, that's my understanding.
And there were 6 tasks. I won't go through them all, but do you have an estimated man hours for these tasks?
Yeah, thank you for asking about that, because we were giving that a bit of thought, and we looked at how much time we spent in the previous engagement, which was around 700 hours. I think it really depends on how the process evolves, and surprisingly, it may be that by giving us more time, we end up taking less time, simply because we're able to plan things out in a different way. And but also, I think that the issues in this proceeding will be a bit different. So I realize that broad ranges are sometimes not helpful, but since we have the example of the previous proceeding, I can't throw out the 700-hour number as being outside of the realm of possibility. But I think a reasonable range is probably between 500 and 700, recognizing that in the previous proceeding, we found one of the dockets to be much more intensive than the other, and it's possible in this proceeding that both could go smoothly, and there would be fewer issues. So I'll put that range out there, and beg your apology for the fact that it is not narrower.
Understand. And I guess relative to, the last go-around in avoided cost hearings, do you anticipate anything different this go-around? I mean,
well, I think, as with all iterative processes, I think that folks learn and evolve. So I'd be surprised if there weren't a few things that were different in the way that the applicants approach the requirement. So I'm not anticipating that the subject matter will necessarily be different, or the volume of material to review. I mean, one of the differences, last time, there one set that were pursuing a settlement, and one set that weren't. That certainly has implications. I mean, ultimately, our role is to be independent, regardless of whether a settlement is reached. But nonetheless, I think whether or not parties reach a settlement does impact, the number of interrogatories that are launched. It does reduce the work to a certain extent. And so whether or not there is a settlement in either of the or any, I should say, of the dockets will have some impact on the amount of work that's required.
okay, but whether there is a settlement or not, you recognize it's still an independent assessment on the firm's part regardless of that, correct?
Absolutely. I mean, settlement can mean many things. There may be something that is not consistent with the statute, and it's our job to say that. So I don't think that the reports look different. I think the only point that I was trying to make is that sometimes there's fewer back and forth interactions to review if there's a settlement than if there's not a settlement. Doesn't change what we write about or how we approach it or how independent we are.
Understand, thank you. And I think you had mentioned also that relative to modeling and such, is it your firm's general idea, I guess, to replicate the utilities model or to, I guess, use the input information within your system to determine the reasonableness of those numbers?
Yeah, I think the approach that we've tended to take in similar circumstances is to say, let's use similar inputs, let's run them through our models, let's see if we get results that are consistent with what the utility is putting forth. You're never going to get results that are exactly the same. And the fact that they're not exactly the same doesn't mean that anybody necessarily made a mistake. It's just that the models work differently. And so what we focus on is, directionally, are the results similar and are they within a reasonable bound of error that we're comfortable saying, look, we can support what the utilities have said. So if we have questions about assumptions, if assumptions look anomalous, we will say so, perhaps fire back some clarifying interrogatories. But ultimately, we find that the benefit of being able to run these things through our own models is that we can have present a clear understanding of how other folks might interpret the assumptions that are being put forth. And if we can come into the same range, that gives us a lot of comfort that the results are sound.
Thank you. Does LEC outsource that type work, that modeling, or do you guys do that internally?
We do it all internally.
It seemed like I had so many more questions, but I just can't find them right now. So rather than say I have no more questions, I'm just going to say I'm through for now, and perhaps I'm through. How's that? Thank you, Vice Chair.
Thank you, Commissioner Caston. I'm going to jump back in, Mr. Goulding, if that's okay, and even if it's not actually, but I'm going to. Mr. Goulding, you're aware of the parties that were involved in the last case on a number of solar business groups or solar entities themselves or conservation clean energy groups, the Office of Regulatory Staff, Department of Consumer Affairs, both of whom represent the public interest of ratepayers in South Carolina. Can you tell us if you've had any business dealings with any of those? We don't know who's going to be in the current 2023 dockets, but with respect to the parties that we dealt with before, have you had any business dealings with any of those, including the utilities?
No, we have not.
Okay. Do y'all currently represent any solar developers, solar trade groups, or any or even any public investor-owned utilities. Do y'all currently represent any of those that might sway your opinion?
Certainly not any that would sway our opinion in any way. We, in the normal course of business, almost always have some public utility clients. I don't think we currently have any I guess we have one solar developer. Recently, there's been a lot of interest in terms of batteries, so we've been doing a lot of work with battery developers. None, to the best of my knowledge, that are active in South Carolina. And in any event, the work that we do with all those entities would have no impact on our independence in this particular potential engagement.
Is LEI a member of any trade groups or trade organizations?
So I think we're a member of both the Ontario and Alberta Independent Power Producers Associations, and we're a member of I think they're called the New England Energy Commerce Association or something. These are fairly broad umbrella groups that virtually anybody can join. I don't believe there's any way that our membership in those organizations would impact our independence in this case.
If your firm is awarded this engagement, do you have mechanisms in place that would allow y'all to ensure that you don't engage other or get other engagements that could create a conflict with this one?
Yes. Once an engagement like this is signed, then we have an internal approvals process that would cause any other potential conflict to rise to me. And then if we had any questions about it, we would run it through your process, understanding that it has to go through through all parties. But our process is that conflicts are identified in regular interactions before a commitment is made.
Thank you. Have you has you or your when I say you, I'm talking about LEI, but let's just say, has LEI previously been engaged by, other than South Carolina, in the last proceedings, engaged or retained by a state or federal regulatory commission to serve as an independent advisor or consultant under similar circumstances as what we've got here?
So the work that we've been doing recently for state regulators has tended to be either based on gas or electric utility of the future type proceedings, or regulatory proceedings related to performance-based rate making. So not PURPA related.
Okay. But those do not include any of the utilities involved in these three dockets, is that correct?
That's correct.
Okay. And I know Commissioner Thomas asked you some questions about employees that have left to go work for utilities or solar companies. Do you currently have any employees that might be working on these projects that formerly worked for public investor-owned utilities, electrical utilities, or solar entities?
Just before I answer that question, let me just amend my answer because I just realized something.
Okay.
The work that we do for the Ohio Commission which is involves management audits. One of the utilities that is reviewed is a Duke subsidiary. Um, I don't believe there's any, crossover to these proceedings, but I wanted to make sure that I was accurate in my response. So I just wanted to point that out.
Thank you for that. And let me just clarify, the nature of that work was a management audit, is that correct?
Yes, that's correct. It was basically to review that numbers submitted to the regulator are consistent with what they should be, and that the appropriate procedures were followed, consistent with the regulations in the state of Ohio.
Okay, but it did not involve anything with the calculation of avoided cost or the contracts, the purchase power agreements, the notice of commitment forms, or anything that would that the issues of a proceeding such that we're getting ready to look at.
That's correct. While the costs of certain power purchase agreements may have been included in those proceedings, again, it's really about, okay, you entered into a contract that said you were supposed to do X, or sorry, that you were acquiring power for whatever price. Did this flow through the accounts? Did the ratepayers get charged what they were supposed to be charged, or not? So the nature of the proceeding is very different from an avoided cost proceeding.
Just so that we are making sure that everything is transparent and clear, would you address that consulting agreement in the final conflicts letter?
Absolutely.
Thank you.
And now let me answer your other question, which I believe, correct me if I'm wrong, was whether any of our current employees previously worked for a
Investor-owned utility or any of these any solar entities.
Just going back through them in my mind, we have one colleague who has now been with us for more than 7 years, who formerly worked for a large Canadian provincially owned vertically integrated utility, but we don't have anybody who formerly worked for a U.S. investor-owned utility.
Well, and that was the follow-up was going to be, would it have been any of the parties that were in the last docket or doing business in South Carolina? Okay.
No.
Let's see. I have a lot of notes I'm kind of going through, so bear with me if you would. You had mentioned that y'all have some proprietary models and analytical tools. How do y'all plan to utilize those tools if awarded this solicitation, and does that give your firm any advantage over another firm in how they may conduct review or modeling?
It's an interesting question, because I think one of the things that we believe is that knowing the innards of the model helps you to better understand the outputs. And so it's less of a black box to us. And so we can speak with greater confidence to the outputs. There are many different ways of approaching an engagement like this. I think we believe that by applying our own models, we can further substantiate the opinions that we have. And if you're able to get to the same or similar results using different approaches, that tends to reinforce the idea that the results are valid. So while I would say that the fact that we have our own model and 2 decades worth of experience working with models is an advantage. I don't want to discount the possibility that other smart people could use a different approach that would be valid. I think that ours has been successful in the past, and I'm confident that we could deploy it successfully where we granted this engagement.
This may be a bit repetitive, but just want to restate this and just to make sure. But has LEI served in an advisory or consulting capacity or received compensation from any party to this docket, including the investor-owned utilities? And since we don't know who all the parties will be in the upcoming ones, maybe the parties that were in the last one, in the last dockets, I hope you've had a chance to review those.
Yeah, to the best of my knowledge, we have not received any money compensation, anything from any of the parties that were party to that docket.
Okay. And in response, I believe it was to Commissioner Thomas, you indicated that that LEI, I believe it was LEI, someone had done some work for Dominion 15 years ago or something like that. That was not Dominion, South Carolina. Is that correct?
That's correct.
Kind of obvious since there was no Dominion, South Carolina 15 years ago, but I just wanted to make sure about that. Have you or anyone that might be working on this project or LEI adopted or advocated for positions in any public forum on any of the issues that could be expected to come up in an avoided cost proceeding, whether it be the avoided cost rates, terms of PPAs, or other documentation, that type of thing?
No, I don't believe so. We haven't advocated for anything with regards to pricing or to particular methodologies. I don't believe there's any testimony about that from myself or from anybody else in the firm.
Okay. Does your firm have experience with assessing, regulating reserve requirements of a utility system?
Yes. There are a few different contexts in which we've looked at things like that. In some instances, we've been asked to value those particular services or to try and model a market for them. This becomes a bit more challenging because the resources that can provide these kinds of services are a subset of the resources that act in the market as a whole. We have not provided testimony on that particular topic, but we have worked with it in the past.
How about dealing with ancillary services requirements and studying, planning for, or maintaining the reliability of a transmission and distribution systems?
Yes, these are topics that, again, we haven't provided testimony on outside of the previous proceeding, but that the role of ancillary services is an increasingly relevant topic, given the amount of intermittent resources that are coming on to most systems around the world. And so almost every discussion that we have about wholesale market design has some element of what should we do about ancillary services that's embedded within it.
But are these topics that y'all are comfortable studying, discussing, and addressing should the need be there in a final report?
Okay. Yes, absolutely.
Can you briefly explain any experience that your firm or you have with regard to modeling or studying the South Carolina power system?
So We model all regions of the U.S. And so in our southeastern model, we incorporate all the resources that are in South Carolina and all of the load that's in South Carolina. So as part of what the firm does is approximately every 6 months, the firm updates its regional models across North America, and that includes all of the continental U.S. And so obviously by extension it includes South Carolina.
Does LEI have experience with investor-owned utilities IRP processes? And have y'all ever filed testimony or staked positions on IRP proceedings?
We do follow the IRP proceedings. In fact, they're critical in doing modeling for those jurisdictions that are not part of ISOs or RTOs. However, we have not filed anything in IRP proceedings. We have been independent evaluators in procurements that were the result of IRPs, but we have not had any filings that are directly part of an IRP proceeding itself.
Could you explain or describe any experience or knowledge with regard to utility system production cost models that may be used by utilities for their IRPs and avoided cost calculations?
Yes, I mean, in addition to deploying our own production cost models, we've also reviewed those of others. At times, we've been asked to license those models to use them in other contexts. So we've directly, I think, reviewed or used under license Plexos. We've also reviewed Aurora and one or two others. So we're familiar with production cost models, with a range of production cost models. Now, some IRP processes use a production cost model, and then they also use other tools in order to come up with a more comprehensive plan. But we're quite familiar with production cost models.
Okay. Mr. Goulding, I think I'll look back through my notes, but for now, that completes my questions. I do have a note from Commissioner Caston that he has a couple of more questions. Thank you very much for your attention today.
No worries.
Thank you, Vice Chair Belson. Mr. Goulding, as I looked through my notes, thoughts more about some of the questions. And I wanted to make sure I understood it. If there is a settlement or any settlements, your firm would still review all the filings in the docket. Is that correct?
Yes, that's correct.
And so with that, you complete the same analysis whether there's a settlement or not.
Yes, that's correct.
Okay. The team members that you would have on this particular project or these projects, could you kind of describe those team members briefly that you would have working on this filing?
Sure. I would have two other colleagues that would be primarily on this. They're the same people that worked on the previous engagement. Both of them have been with the firm for more than 5 years. They're very experienced with both production cost modeling and in thinking about avoided costs. Their backgrounds are in economics. In addition, they would be supported by the rest of the firm when needed. And so, for example, we always try to be efficient in who does what. And so if we have the opportunity to use somebody that is very good, but we can charge you at a lower rate for them, we would certainly incorporate them on the team if there's some research tasks that are required. I think our view has always been that you don't get the best result by throwing tons of bodies at a project. What you want are focused teams that devote the time and attention to the project that's required, and that can then use other resources within the firm for basic tasks. So that's how we would staff this. There'd be myself, two other primary individuals, and then folks at the research level if required.
Thank you. And that got me thinking, about continuing education. And probably has nothing to do with any of this other stuff, but I was thinking about your team or whomever does this. What does LEI's continuing education look like? How do y'all stay abreast of things?
Well, I mean that is a great question because you've got all the work that is on your desk at the moment, plus you have just what's required to stay abreast of everything from hydrogen to thinking about EVs to looking at transmission NOPRs. It would be easy to spend your entire day just on staying up to date. And so what we've tried to do, look, I'm a bit nerdy. I'm slightly ashamed to say that I've read, I think every daily issue of Megawatt Daily for the past 20 years. That's not necessarily something to be proud of. But we encourage everybody in the firm to follow at least one series of trade press. And in order to make sure they're actually doing it, in our weekly calls, each person presents something from the trade press. And we found that's a good discipline. In addition, every member of our firm is encouraged each year to put forth a professional development plan that the company will pay for. Sometimes that includes, going to ISO trainings, which are usually, cost effective. Sometimes it's staying abreast of things that are happening at NARUC or its Canadian affiliate. And sometimes it involves going to some formal, academic style training. So I'm not going to tell you that we have the perfect answer, but I am going to tell you that it is something that we're very attentive to, because in professional services, you either you adapt or you die, and we are certainly not doing the same things that we were doing 20 years ago. So I'm sure I would benefit from your insights on the subject as well.
It is a struggle, isn't it? Finally, I think this is my last question. Thinking about your willingness to do the work for 1, 2, or three of these utilities. Could you comment on the advantages to doing all of them, or one of them, or two of them?
I think there are economies of scale in doing all of them. That I think that there is some duplication if you end up having multiple service providers, and I think there is also the potential for there to be some inconsistencies in approach. Now, you as a client, you may decide, hey, we like having access to more than one perspective because it helps us to see the world through a few different lenses. But I think the trade-off is you probably are going to pay a little bit more for the teams to wrap their minds around the issues of the day. And there's the risk. I mean, I sometimes find myself in conversations where people are using the same word, but they don't mean the same thing. And there's a risk when you hire two different professional services firms that perform similar tasks that they will use the same words and not necessarily mean quite the same thing. And then you have to sort of think, okay, well, in this proceeding, when they said X, did it mean the same thing as what was meant in the previous proceeding? And so there's pros and cons to both. And I think ultimately I feel that there was an advantage to having us do all three the last time. And I think there would be economies of scale the next time. What you lose out on, of course, is just having some other voice that looks at things in a slightly different way.
So in the economies of scale, when you're talking about that, I'm assuming you're talking about basically a better value, a better cost if all three versus one or versus two. Is that a fair assessment?
Yes, that's correct.
Okay, I believe that's it. Thank you very much, Mr. Goulden.
Thank you.
Thank you, Commissioner Caston. Any other commissioners with questions? Hearing none, Mr. Goulding, on behalf of the commission, I'd like to thank you for being with us today and responding to our questions. I will note that there is a final conflicts letter. I believe it's due by close of business next Monday. However, if I am saying something that is inconsistent with the scheduling order, go with the order. So, do you have anything that you need to ask us?
No, just to express my appreciation for the opportunity to present our qualifications.
Well, thank you very much. We appreciate you being with us today. And as there are no other questions from commissioners, we'll close this special business meeting and hope you have a good day. Thank you.
And you. Cheers.